Not guilty. We had a trial in Marion County, a jury trial. It was actually a co-defendant case. Our particular client was charged with felony charges for battery on a person under the age of 14, while him himself was over the age of 18. In the state of Indiana, that is a felony 6. The co-defendant was actually charged with battery on a minor under the age of 14 causing injury, which is a felony 5, as well as aggravated battery as a felony 3. But get this, the aggravated battery was actually against our client. So our client not only is a co-defendant, but he's also a victim of his co-defendant's main charge.
I've never seen it before, and in fact, I don't believe the judge has ever seen it before either. Between the prosecutors, the 2 defense attorneys, and the judge and the court staff, this seemed like a first time that they've come into something this crazy.
And it's really weird because after the trial was over, that was actually one of the first questions the jury had asked us. They asked why both defendants were facing charges at the same time, and we didn't really have a great answer for that because Zach and I actually tried to separate the 2 cases, but in this particular case, the judge determined after argument from the prosecutor that for judicial economy, it was actually easier to just try them both at the same time because both cases would have been the exact same witnesses, the exact same people from the state, and the exact same argument. So it would have just been easier at the outset to just basically do this 2 cases at the same time. Yes, so the state of Indiana actually wanted these 2 cases to be tried together. Something was incomprehensible to me because my client is the actual victim of the lead charge. So it put the state at a disadvantage because they couldn't call what would have been their star witness against the other defendant who's facing a felony 3.
Because we would have told our client to plead the 5th. It's the same trial. If he wanted to testify as a victim, that opens him up to cross-examination on the charges that he was there for as well. Not a good situation that we wanted our client to be in.
Of course we did. There wasn't anything in our minds that we thought rise to the level of an actual crime. Now, there are certainly facts about this case that we didn't like. They didn't sit well with us because it's ultimately 2 men grappling over a small child. But in the grand scheme of things, you can't punish childish behavior if there's actually no crime.
We did attempt many times to reach out to the prosecutor and explain the situation, that if they could dismiss the charges against our client, that he would testify as their star witness and get the more higher serious level 3 felony conviction for the state. We've asked many times, and every time they told us no.
Of course not. We would always continue to try to go back because our job is to get the best possible outcome for our clients in every single situation. Now, sometimes that means going full throttle ahead with trial and nothing but trial. But in this particular instance, our client had value to the state of Indiana if he were to testify. Again, there were still some issues long-term with the actual charging of the aggravated battery. So even if our client testified, doesn't necessarily mean it would have led to a conviction, but it certainly would have helped the state. So are we going to stop trying just because they tell us no once? Of course not. Especially when we actually have the upper hand, in my opinion, and we can actually offer value to the state if it were to come to that actual part of the trial. Number one, you always got to be able to go to the mat for your client. There are a lot of times that a client will come to our office, hey, Matt, hey, Zach, I didn't do anything here. I'm a victim. What's going on? Why are they coming after me? It's just not fair. We hear those questions all the time. And sometimes it takes a deep, deep delve into the case to realize, hey, you know what? We do got to go to the mat here. On the flip side, like I said earlier, provide some value to the state of Indiana. Number two, the big value here is for the client. The client gets to see us in action. The client gets to see someone fight for him when he has the opportunity to feel like everything's against him. The state of Indiana is coming down on him. The judge is saying, no, you're going to sit next to your co-defendant who actually battered you during this trial. So this entire time, he's getting the feeling, you know what, no one's fighting for me. I'm just this person. So that's kind of the main takeaway is he's got two people here that are actually going to bat, fighting for him, going to war for him in trial. And that is absolutely invaluable, and it makes people feel appreciated. In my opinion, there were a few. However, one of the ones that came about, again, as I was talking about earlier, this became a situation between two grown men grappling over or tussling over a child. The child is actually the biological child of the co-defendant and our client's stepdad. So in this particular instance, we were talking about not just a stepdad, but a dad that stepped up.
The jury came back not guilty on both our client and the other guy as well, so not guilty across the board. Yes and no. On one hand, he's very happy that he was found not guilty because he knew all along he wasn't guilty. On the other hand, he was a victim in this case as well, and that other guy basically got off with nothing.
Absolutely not. Again, it's always our client's decision. Do I want to go to a trial? Do I want to take a plea? And in this particular case, our client and both myself and Zach, we were lockstep the entire time. We knew that this was going to either have to be dismissed, either through a diversion program or outright dismissed, or we were going to do a trial. There was never a situation where we agreed that trying to abandon ship in order to try to get the bigger fish, which would have been the co-defendant, was ever going to be a viable option. So the advice I would give myself and Zach from 2 years ago is buckle up, do the work, get ready for the not guilty verdict, because nothing's sweeter. I want to say it's because the actual event occurred in the brand new Justice Center. In fact, the Justice Center had been open for about 3 weeks at this point for actual court hearings. And in fact, the criminal side wasn't even open at this point. So it did get some media attention. And I think that it came down to a point where, number one, if they were to have been severed, it's likely our client's case would have been kicked into a different court, because into a misdemeanor felony 6 court. So then you have two different defendants in two different courts getting ruled on by two different judges. So given the media attention and given the fact that this actually happened in the brand new Community Justice Center, I want to say that's the reason why the prosecutor was so adamant on keeping these two cases together. Without being in her actual mind, that's what my thought is.
They sure did.
Yesterday and today, Attorney Zach Ritchie and I have been in Marion County doing a co-defendant jury trial. Our client is charged with felony 6, battery on a minor under the age of 14, while the co-defendant is charged with aggravated battery as a felony 3 and battery on a minor resulting in injury as a felony 5. Zach, what are we doing right now, man?
Waiting for the jury. I got it about an hour and a half ago, so we're just sitting here waiting.
Well, I guess I'll start. This is the hardest part for me because it's just been a complete emotional experience, as every jury trial is. So anytime you do a jury trial, it's extreme focus. It's hammering in on one case specifically. So it's a bit of an emotional drain, but it's also a situation where you're a little bit nervous as you sit and wait for the jury, knowing that they have the ultimate say. Overall, though, I would say I'm feeling pretty good.
Nervous, but feeling great.
What's going on, everybody? So I know the last video you saw, we were sitting waiting on a jury verdict. Jury came back not guilty for our client. We could not be happier. Client deserved it. He was an amazing client, great listener. But in the grand scheme of things, when it was all said and done, the state didn't meet their burden. They've got a very high burden, and they just didn't meet it.
So this was a level 6 felony battery on a person less than 14 years of age, and the child in question was actually our client's stepchild. There was a big custody hearing going on in this exact courthouse where the trial was held. And there was an incident between the real dad and our client, the stepdad, which ended up in a little tussle between the children that ultimately led to the child unfortunately getting hurt.
Obviously, the facts surrounding the case, they were very, very difficult. No one ever wants to see a kid get hurt. In full disclosure, the kid is totally fine, completely healed.
Yes.
But all I can say, our client's ecstatic. It's been a great, great day. It's been an exhausting 2 days, but we couldn't be any happier for our client. And if you ever find yourself in a situation where you're facing charges, give us a call, 317-632-3642. And remember, always plead the fifth.